Good afternoon, folks, or good morning, depending on your time zone. Thank you once again for joining me here at the ABA Division for Public Education social media streams. I am pleased, as always, to be joined by Professor Stephen D. Schwinn of the UIC John Marshall School of Law. Professor Schwinn, thank you.
Good to be with you again, Kathy.
Happy March.
Happy March.
As we've gotten underway with the court's March argument session, there was a case argued earlier this week that got quite a number of headlines dealing with the Voting Rights Act, specifically Bronovich versus DNC, a consolidated set of cases. Professor Schwinn, as you know, this asked the court to take on two challenges to the way Arizona does its elections, one being a policy where they threw out ballots that were cast in incorrect precincts, and the second being an Arizona state law that prevented the collection of ballots by third parties, sometimes referred to as ballot harvesting. The argument in this case saw discussions about intent tests and purpose tests and disparate impact and a whole bunch of jargon. Can you unpack this for us? Tell us how this got here and give us some background on Section 2 of the Voting Rights Act.
Sure. So as you said, Kathy, this involved two Arizona electoral practices. One is the out of precinct policy, where Arizona actually tosses ballots that are submitted in the wrong precinct. And the other is the third party ballot collection policy. Arizona law bans third parties, except in very limited instances, from collecting ballots from people and then submitting them on behalf of others. This is, as you'd mentioned, sometimes called ballot harvesting. The Arizona authorities say that they adopted these measures in order to prevent fraud in the state, voting fraud in the state. Opponents of the measures brought a Section 2 challenge under the Voting Rights Act, arguing that these measures had a disparate impact on the rights of racial minorities in the state to participate in voting and to elect candidates of their choice. The claim under Section 2 is really the crux of the matter. So Section 2 of the Voting Rights Act prohibits racial discrimination in the vote. The Supreme Court had at one point interpreted Section 2 to mean that it only prohibited intentional racial discrimination in the right to vote, which would only apply to a narrow set of state practices that denied the right to vote to racial minorities, only those where the state intended to discriminate. Congress in 1982 amended the act to say that state practices not only that intentionally discriminated, but also had a disparate impact or disparate effect, an effect of discrimination, could also violate Section 2. And so the question here is, how do you measure that? The plaintiffs brought their case against the out-of-precinct policy and the third-party ballot collection policy, and they actually won in the Ninth Circuit. The Ninth Circuit adopted what we call a results test that looked at the racially disparate impact in the way that these policies are implemented. And the Ninth Circuit said, yeah, it's true. Racial minorities are disparately affected by these policies. And then the Ninth Circuit went on and said, can we connect the policies to the social and historical conditions of racial minorities in the state of Arizona, given everything else that the state has done over time to discriminate against racial minorities and the right to vote? Can we make that connection? And the court said, yes, we can. And therefore, the court struck these two policies as violating Section 2. And now the case is at the Supreme Court, and that's the important question for the court.
So, Steve, one of the things I felt during this oral argument was this was just the justices struggling with a bunch of different test options, trying to develop their own tests. Can you talk about a little bit more about the results test and what the other potential tests were that the justices were struggling with in looking at how to assess these sorts of restrictions on voting?
Yeah, for sure. And we can, even as we're discussing this, I hope that listeners are kind of getting a sense of how hard it is. How do you measure disparate impact or disparate effect, an effect of racially disparate voting practices? How do you measure that, and at what point do you determine that to be illegal? Well, we can think about this as kind of a spectrum of options, right? And so one option on one far end of the spectrum, the Arizona Republican Party was saying, look, Section 2 really ought to only ban those practices that result in a diminished opportunity for racial minorities to vote, a diminished opportunity. And it became clear in the questioning, well, we're not really sure how to measure even that, right? What does it mean to be a diminished opportunity? So on one end of the spectrum, we can talk about equal opportunity as a principle animating Section 2. The test that the Ninth Circuit adopted would be a sort of middle position, maybe, where the court looks at whether there is in fact a racially disparate outcome, and then second, can you tie the policy to the historic and social conditions of racial minorities in the state in order to connect the policy to that disparity, right? And that would be a different position. Yet a different position would be, why don't we look at the disparity first, right? Is there a racial disparate outcome? If there is, then let's let the state justify its action in race neutral terms for race neutral reasons. For example, maybe as Arizona said, a state adopted these measures in order to combat potential voter fraud. If so, that would be racially neutral. But then the question becomes, did they really do it for that purpose, or are they using a racially neutral justification as a cover for racial discrimination? As the argument went on, it became more and more confusing how to distinguish these tests and how to measure them. And at one point, Justice Kagan even said, look, we've been at this for nearly 2 hours. I'm as confused as I was at the beginning, and I don't even know what the difference between these tests are. So as you said, Kathy, I think quite rightly, the justices are really struggling here to figure out how to measure this.
Yeah, I appreciated Justice Kagan putting my own frustration into her words, because this was just really confusing and really hard to sort of track the different nuances of these proposed tests. I found myself really wishing that this was an argument that was taking place in person, or at least with the less rigid sequential questioning. And I found it to be one where I thought perhaps if there had been more time for some back and forth between the justices themselves, some of these nuances could have been drawn out a little bit more, and we could have been maybe able to read the tea leaves a bit more as to what a general consensus about these tests might be. Steve, what were some of your big takeaways from the oral argument beyond sort of general confusion and befuddlement?
Well, what you just said, I think, is one of the biggest takeaways. I think you're spot on with this, Kathy. We often think about oral arguments as justices questioning the attorneys to get information. But justices use oral arguments as often to communicate with each other about the ideas that they're thinking about. And if we would have had the kind of give and take that we have in in-person arguments, I think we'd have a lot clearer picture of where the court's going with this. So that's one takeaway. Another takeaway, I think, is just at the end of the day, I think the court is likely to uphold these Arizona laws under whatever test it adopts under Section 2. And then I guess the third big takeaway is that the justices really, I think, seem to be struggling for a Section 2 test. And this is going to be hugely important in the coming year and years ahead as more and more states are looking to amend their election laws in order for the stated reason of combating voter fraud after the 2020 election. Now, whether they're actually combating voter fraud or adopting their election laws for other reasons, I think that's part of what this case is going to. And moreover, as states get their census results back and start to engage in redistricting based on the 2020 census, we're going to see more and more Section 2 challenges against state practices with the right to vote, state redistricting practices. And what the court says in this case is going to be hugely important in terms of what state voting practices will stay on the books for the midterm elections in 2022 and the next presidential election in 2024.
Steve, I appreciate you putting it in sort of the broader context and really making the significance of this case so obvious or clear. I'm wondering if you could also talk a little bit, we've got a little bit of a prediction from you on what you think might happen with these Arizona laws specifically, and to keep that prediction hat on and talk a little bit about what you think about sort of the future of the Voting Rights Act. Will we get another version of it in the future? How would that be challenged before the court? Where do you see this? You've talked a little bit in the next 18 months, maybe 5 years down the road from now.
What a fantastic question. And so, I think in the immediate future, I think what's likely to happen is the court is probably going to uphold these voting practices under Arizona law. Again, I'm not sure what standard it will adopt, but whatever standard it adopts, I think we'll probably have 5 or 6 justices that will uphold Arizona's laws in this case. What it means more long term, this is kind of an interesting question. There's been some buzz about whether Section 2 can be used to ban racially disparate impact practices in voting. And the question is, does Congress have authority under the 14th and 15th Amendment to enact a provision like Section 2 that would ban racially disparate impacts as opposed to merely intentionally racial practices, right? Mm-hmm. And those are two meaningfully different things. The disparate impact reaches a lot more practices than disparate intent would reach. And so there's been some buzz in the air about whether Congress has authority to enact a Section 2 that would ban racially disparate impacting practices. Now, that issue isn't directly before the court in this case, but it comes close to it because what some of the attorneys are arguing is that you have to adopt, say, my rule, right? The Arizona Republican rule, for example, in order to avoid running afoul of, in order to avoid creating an act that exceeds congressional authority under the 14th and 15th Amendments. And so what does this mean longer term? I think this is going to be the first case maybe in a series of cases where the court's looking to the scope of Section 2 of the Voting Rights Act and asking itself the question, does Congress have the authority to enact this? And if so, what are its metes and bounds?
Yeah, I agree with you entirely. I think Shelby versus Holder was such a landmark and important point in these voting rights cases and sort of what's Congress's authority, what are the states allowed to do under that authority. And depending on whether we get a clear decision, a clear opinion coming out of this on the testing and sort of what the court thinks, I think that this could be the next step. And as you perfectly said, perhaps the first in a series of cases to come out.
I think that's probably right. Kathy, let me shift gears for a second. One of the things that occurs to me about this and that I really enjoy talking to my own law students about is the difference between racially discriminatory intent and racially discriminatory impact, right? Again, two meaningfully different things. And what that means in the context of any discrimination law, but here in the context of voting laws, I think you could do some really interesting things in the classroom with that difference and helping students understand what the difference is and why it's important in Section 2 litigation, for example.
Yeah, I totally agree with you. And I would point any educators looking to maybe use this case as a window into that to pull out the hypotheticals that Justice Kagan started to go through with, I believe it was the Republican Party attorney from Arizona. She set up these really wonderful hypotheticals that were really spelling out, could you set up polling at a country club? And what would that mean for Black voters? If you shifted the time from 9 to 5 that a poll was open to 10 to 3, and this notion of intent versus impact, I thought was really, really compelling. And that was one where I really wished there had been more time for the other justices to weigh in and maybe push those hypotheticals a step further. Because it is such a nuanced distinction that when you explain it is very clear, this sort of impact versus intent, but in reality can be really, really challenging. I also think some of the federal housing discrimination cases are great ones. I think the court has been fairly clear in those and in the application of those, or at least in the analysis of those. And there's some really wonderful case studies that you can pull out of those cases specifically to help students really see the difference of those in practice.
Yeah, and these are really hard questions, right? And can really animate a class and get a class going. You get some really interesting class discussions about the difference between the two ways of viewing discrimination and what that means on the ground in actual practice.
Yeah. Steve, I appreciate you turning our attention to sort of classroom application, because that's something I've been thinking about with this case as we were getting ready for this chat. One of the things I really would love it for is as a jumping off point for some student-based inquiry into what a fair election is. So having students themselves really look at this case, but look at the entirety of the voting rights cases over the last decade and a half, as well as what we've seen in the last 6 months, and allow them to think through what makes an election fair. What are the factors that you need? How do you enforce a fair election? And by enforcing, are you inherently making something unfair? And really having students kind of weigh what the justices were weighing this last week and go through those themselves and really for themselves create a definition.
I love that. I think nothing drives the point home more than asking students to actually do the work of developing policy, and in this case, for a free and fair election. And what better time, right? I mean,
Right.
so many states now are looking to amend their election laws. And so, there's a lot of material out there that we can look to and use as samples and bring into the classroom to help our students understand the implications of their decision making.
The other thing, as you said, do the work that I would love to engage with some students in is we've talked in the past about having students as they sort of are thinking about taking action in their own community, particularly as it relates to elections and voting. Many of them aren't yet 18, so that we ask them to maybe create a get out the vote campaign in their community or talk about voter registration campaigns in their community. And I think what was so interesting with this Arizona case is some of that get out the vote was tied up in this ballot harvesting allegations, and in particularly as it relates to Native American communities that are rural, and someone needs to bring the ballots into the precinct. And so one of the things I would ask students to do is to investigate in their own community. What are the challenges in accessing the pool, but also what are the limitations or restrictions on ability for people to help others access the pool? And how do you create a voter mobility drive within those confines? And maybe also how do you challenge some of those restrictions?
Fantastic. I love that. Yeah.
Yeah. And the last thing I wanted to talk about as we are thinking about this in a classroom setting is placing this within the recent launch of the Educating for American Democracy roadmap. And I was really excited to look at the challenges and the themes within the EAD roadmap as I was listening to the oral argument and sort of thinking about where this particular case would sit and where some of the other cases we've talked about throughout the term and may talk about going forward would sit. And what I found was really exciting, and I would encourage any educators watching this to think about and to look at the roadmap, because there were a number of themes that the developers of the roadmap had identified that I think that this could really sit inside. Civic participation obviously being the most obvious one. The We the People theme, how do we define the electoral? How do we define who gets to vote? How do we challenge the government within that? Being the second obvious one, but the one that I found to be really interesting was the theme on the changing landscape of the nation, and the idea of, particularly in this case, as we mentioned, the Native American tribes and the land that they live on is so remote, and it doesn't sit in the same structures as being able to go to your local school to vote on a random Tuesday morning at 10 a.m. And so how does that actual landscape that we live in and on impact our ability to exercise these democratic values and norms? I think is really interesting to explore in this sort of case. And I was really energized to start thinking about how we can put some of these cases within those EAD roadmap themes.
Yeah, fantastic. Again, perfect. And the timing for this could not be better.
Yeah, absolutely. Well, Professor Schwinn, thank you as always. I look forward to our next chat, and we should hopefully be getting some decisions that we can start unpacking in the near future too.
Thanks again, Kathy. Good to be with you.
Bye-bye.
Bye.